Good afternoon, everybody, and welcome. Thank you for joining us today for this presentation, Intellectual Property Protection for Small Businesses. Can I get a quick hand raise from attendees letting me know that we have good audio? Thank you. Your host for today's webinar is the Mohawk Valley Small Business Development Center. The Mohawk Valley SBDC is part of the New York Small Business Development Center's network of 22 campus-based centers and outreach offices across New York State. Our centers provide free business advising and research, as well as free or low-cost training to startups, entrepreneurs, and small business owners. I'm your moderator, Zach Steffen. I'm a business advisor at the Mohawk Valley SBDC. A couple housekeeping items before we get started. If you have any questions, please type them in the question box. The presenters will be addressing questions throughout the webinar and during the Q&A session following the presentation. All attendees will receive a follow-up email later this week containing the slides and a recording of today's webinar. With that, I'll turn things over to Brian Gerling, who will introduce today's presenters from the Syracuse University College of Law's Innovation Law Center.
Well, thank you. And good afternoon, everyone. I am Brian Gerling. I am an adjunct faculty member at the Innovation Law Center at the Syracuse University College of Law. I am also a practicing attorney in Syracuse, New York with Bond, Shenick & King. I am a graduate of Syracuse University College of Law and also a graduate of the ILC program. So there's proof positive that the program actually works, and you can get a fruitful career through the program. I want to talk a little bit about the program, about what we do. So essentially I apologize, it's so hard not seeing the audience out there, I only see the presenters, but a little atypical from what I'm used to. But in any event, what we do at the Innovation Law Center, we are a NYSTAR funded program, and that is matched by the law school and other private donors. And we have second-year law students come through our program, and we teach on areas of intellectual property, patent, trademark, copyrights, a lot of the subject matter that you'll hear today. And essentially, we put out a work product for clients. We have real clients that have real technologies and that have real challenges about how to commercialize those technologies. As our fearless leader, Jack Rudnick, likes to say, inventions are just that, but commercializing innovation is the commercialization of those inventions. So how do you actually make money with them, which I'm sure a lot of you here today in the audience are interested to find out. And so what we provide is a report, what I like to call a due diligence report. So you may see later on in the program here a clip from Shark Tank, which I'm sure everyone's familiar with. And all the investors are looking for are, do you have your technology protected? Do you have a patent? Do you have a patent? You'll hear it over and over again. That's what venture capitalists, that's what any investor's looking for. How have you protected your technology such that you can exclude others from practicing that invention and beating you to the marketplace or beating you in the marketplace? And that's what we provide. So we provide a due diligence report where we do a study on the intellectual property, whether or not you can secure a path to patentability, which means secure patent protection for your technology, as well as a freedom to operate opinion, which is what other patents are out there that may preclude you from practicing your invention or commercializing it in the marketplace because there's already a existing patent out there. That doesn't mean you can't. You might be able to get a thing called a license, which we'll hear about later, in order to practice a certain component of that invention that you may be able to tack onto yours and commercialize and make money with your invention. And we also provide from members of, mostly from our Whitman School of Management, a market study. So we provide you with an opportunity, a path to market. What are your barriers to entry there? Who are potential partners that you may be able to partner with? And things of that nature. So we provide you with a comprehensive report that you then can take to potential investors and say, I've done my homework. I know what the marketplace looks like. I know whether I can get a patent or not. I know what my path to patent securing a patent is. I know what other competitors are out there, and that makes you a far more attractive applicant for a venture capitalist or other investor to take a look at. So that's in a nutshell kind of what we do at the Innovation Law Center, and I'd like to now introduce some of the other adjunct faculty members at the Innovation Law Center, and I'll start with Dom. Dom, take it away.
Okay, my name is Dom Dana. I've been with the Innovation Law Center for approximately 5 years now. And my background is in medical devices. I was worked for Welch Allen for many years. I'm not a lawyer. I have a background in chemistry and electrical engineering. But all these projects in the Innovation Law Center, most of them, if not all of them, are fairly technical. So I'm there to advise and mentor and work with all the students to do the reports. Again, let's see what else about. That's about me, what I am. So, Dave, you can take it from here.
Yeah, my name is Dave Eilers. I'm an adjunct both in the Innovation Law Center and the Whitman School of Management, where I teach corporate entrepreneurship. And Brian said, you know, we do a market landscape. And basically it tells you whether there's an existing market or whether you need to do more customer discovery. Do you have good problem solution fit? And if you have that, do you have good product market fit? The other thing we do is, as we do the reports as a cooperative team and collaborate on our client reports, is we tell you whether you might have the best opportunity, market opportunity, whether you spin it into your existing company, whether you might spin it out as a separate company if you're an existing business, or whether to out-license, and who some of those prospects might be for licensing. So that's the market side of what we do at the Innovation Law Center. Really talented senior researchers, and Caitlin will describe her background, and then we'll get into the nuts and bolts of the presentation.
Thanks. So as both kind of Brian and Dave have alluded to, you take the course as a second-year student. Well, before that, so my name is Caitlin Crowbar. I'm a third-year law student at SU, and I have undergraduate degrees in both politics and chemistry. And I came to SU for this program. So you take the program as a second-year student and learn all the nuts and bolts, do the projects for the clients, and then you have the opportunity to apply to become a senior research associate. And if you are selected as a senior research associate, you're afforded a half tuition scholarship for your last year of law school. And then you continue with the program in a more advisory capacity. And so I work with these 3 adjunct professors to help counsel and guide our 2L students in writing their client reports and doing all their research. So getting to that, we have 2 of our 2L students here today who are going to be giving the actual presentation, and the rest of us are kind of here to interject as needed and give some more commentary. So I will pass it over to them and let Chris introduce himself first.
Afternoon, everyone. So my name is Chris Henley. I'm a second-year law student, first year at the Innovation Law Center. I have a background in chemistry. I have a minor in biology. I have research lab experience. I have even business formation experience. I actually formed a C Corp at one point. And on top of that, I have some paralegal experience. I've been enjoying my year at the Innovation Law Center so far and seeing sort of this confluence between law and science. It's a really interesting field, and I'm excited to speak with everyone today. So Sierra, you want to go ahead?
Yeah, thanks, Chris. So my name is Sierra Thomas, and I am also a 2L here at Syracuse College of Law, or SUCOL as we like to call it. I was a biology major in undergrad, and then I triple minored in philosophy, international political science, and Irish studies. So I came to law school to try to be able to mend those 2 backgrounds that I have. And actually, when I came to my visit day here at Syracuse, I learned that the ILC was a thing and that I would have the ability to mend those 2 things. And so I ended up being obsessed with that and coming to Syracuse, and that's why I'm here. I have been in the ILC now for a year, and I thoroughly enjoy it. And so to get you guys just more of kind of an idea of what the ILC looks like, we are going to begin our presentation today with a brief video that describes kind of what we do in more depth. Again, as was previously stated, if you guys ever have any questions, if you just enter them into the questions chat, Caitlin will let me know or Chris know throughout our presentation, and we can answer your questions either immediately or if you want to wait to the end, that is okay too. So I'm going to begin the presentation now. Can you guys see my screen? Okay.
Build it and they will come. Build this technology and you know what? They won't come. A lot of clients, you say, oh, they have this greatest idea and I want to manufacture. And they don't realize what they're getting into. You have to do more than just build that technology. You have to know where it goes, how it goes. You have to know how to sell it.
You have these companies that are very small. They have no employees. For them to successfully take their idea and make it into a business, they have to know commercial transactions, intellectual property, and regulations, and they don't. For us to give them some information, whether it helps them succeed or fail faster, that's very useful.
PCLP is filling an incredible need among university scientists. We're not versed in either the legal or business aspects of particular products or inventions. This group is providing something that's necessary to really look at both the business and patentability side of what we're working on.
The whole point of the tech commercialization program is to get real world experience for students, and what better than to meet local professionals with up and coming projects.
Students come in because they have interest in commercialization of a technology. Some of them have very good intellectual property backgrounds. Some of them have good business backgrounds. Some of them are just curious.
Now, even though this is an expired patent, it would still qualify as a prior art. What you're trying to accomplish with your invention is that you're trying to capitalize on that and use that as a component of your invention.
They're automatically interested in what we're doing, whether that be intellectual property, business law, regulatory law. Everyone seems very eager to learn, very excited to get started.
The work that they performed was simply outstanding. We were able to use some of the research that they did to make our own evaluations and actually co-found a company that's dedicated to try to commercialize these materials now.
What we present gives them a great idea of whether or not their product is going to succeed going forward, or how they can succeed with their product.
There are several critical success factors that must be met not only to enter the industry, but to ultimately succeed within it. The first of which is having key differentiated benefits.
Our program is special because it is tied into the broader concerns, innovation, growth, economic development, progress. That type of knowledge gets honed through our program because it's put into a broader context of transactions and commercialization.
With a device like yours, a medical device, you're going to have to deal with the FDA quite a bit.
Entrepreneurs can probably have some success on their own, but for the most part, one way or another, they're going to have to know some piece or all of everything that will get them.
So that's a little bit of the background about the ILC and what we do. And while we do cover intellectual property protections and the market section and all of those things, today in our presentation for you, we'll actually be focusing on this intellectual property protection that we include in most of our reports. So the different types of intellectual property that could exist would be a patent, a trade secret, a copyright, and a trademark. And these will be the four types of intellectual property that our presentation today will focus on. I'll be discussing the patents and trade secrets, and then Chris will touch on the copyrights and the trademarks. So as Brian alluded to previously, we're going to start out the patent section with discussing with this video from Shark Tank and how, how readily seen it is that people want to see that you have this IP protection, namely patents, in this video.
Do you have a patent on this?
Songs. I am not selling the rights to the songs.
Is it patented? Do you own the patent to the neck hinge thing?
Plush toy industry. You get the patents or not? Yes, I got all the patents.
All of these are patents of mine, and I funded all my
There's
projects.
something proprietary about this, or can you patent this? I'm not even certain.
This is a trademark patent pending product.
You don't have the patent on the real deal here, so I'm out. Oh, a utility patent.
I like the color combination you have there, but is there any trademark?
Do you have a patent on this?
Yes, I do.
We got our patent at that time.
So that's just trying to show you
Do you have a patent?
how investors really do look to see whether you have that patent protection at the outset when they're looking to invest in your invention and trying to get that invention to the market. So with that, we're going to discuss kind of what a patent is and where it comes from. So a patent comes from Article 1, Section 8, Clause 8 of the U.S. Constitution, and that states that the Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So here it's interesting to note that patent rights, along with copyrights, which we'll get to later, are the only rights that are explicitly provided for in the U.S. Constitution, and that again is in Article 1, Section 8, Clause 8. And those are the only rights that are exclusively put in the Constitution. All other rights come from the Bill of Rights or other acts by Congress. So the ability to have a patent is a right that's secured there. And a patent right is an exclusive right that's granted by the government to an inventor. But this is just a negative right. So it's the right to exclude others from manufacturing, using, or selling the same technologies of you. And the patent term is going to be 20 years from the earliest filing date. So when you file to get your patent with the USPTO's office. And for design patents, that's going to be a 15-year exclusive negative right, so excluding others from making or using the same technology as you. So what the requirements for patentability are is utility, patent eligible subject matter, novelty, non-obviousness, and that you have a written description and enablement of what you're doing when you file that patent application. So the first requirement, utility, is typically the easiest to meet, and it's just that your technology does something that's beneficial. It has some use, it has some utilities, it does something. So then the second requirement is that it's this patent eligible subject matter, and patent eligible subject matter can be met in one of four ways. So either the process is patentable, the machine is patentable, the manufacturer is patentable, or the composition of matter is patentable. So to kind of walk through what those four differences look like, we're going to use the example of a wheelbarrow. So with a wheelbarrow, the process that could be patentable would be moving dirt from one place to another through the use of a wheelbarrow. So that would be the process that's patentable. The machine that would be patentable would be the actual wheelbarrow itself. So the whole concrete wheelbarrow would be the machine that's patentable. The manufacturer that could be patentable is the actual process and how explicitly they're putting that wheelbarrow together. And the composition of matter would be the polymer plastic that's used to put together this wheelbarrow in and of itself. So then what wouldn't be considered eligible patent eligible subject matter, excuse me, would be abstract ideas, mathematical equations, or natural phenomena. So what's important to highlight here is if you don't know exactly what you want to do with your technology yet, or you have something that's just an abstract idea, you don't want to be trying to get a patent at this point until you know explicitly what you're going to use it for, because it may fall into the non-patentable subject matter if you have only that understanding. So then the next requirement would be novelty. And this requires that the invention is not disclosed in a prior art. And a prior art is if it's been published in a paper, if you disclosed about this invention in the public forum, so you talked to a newspaper article, or you were just openly discussing this in the public with other people. And the last way you can kind of have this prior art is if you're offering your invention to sell to someone, then that could be voiding this prior art. And the only exception that they'll make for a prior art is if your disclosure was made 1 year or less before filing for your patent. And that has to be by the same inventor. So if somebody else has disclosed in a prior art what you're trying to patent, then they would be disclosed in a prior art and you would not have the ability to patent it. So the next thing to touch on is non-obviousness. And it's not, in regards to non-obviousness, it's not just to a normal lay person. It would be to a person who has the ordinary skill in the art. So for example, if you're trying to make some new chemical compound, or you have some new chemical composition, let's say for the plastic of a wheelbarrow, it would be someone in ordinary skill in the art of having a chemical degree. So, and this is the median level of having that chemical degree. So there's a lot of people who have PhDs in chemistry and a lot of people who have undergraduate degrees in chemistry. So a median level of knowledge would likely be this master's degree. And so that would be who it would have to be obvious to, but non-obviousness will be met if it's not obvious to that individual, not if it's not obvious to somebody who's not working in that field. So how can you kind of see before you file if you're going to meet this non-obviousness requirement versus the obvious requirement? You would see non-obviousness if you're seeing commercial success of your invention right off the bat. You are meeting a need that's long been unsolved within the industry. Others have attempted to do what you're doing and they have failed. You see industry leaders copying you because they're unable to do it in their own way, and you're seeing unexpected but extremely positive results with your invention. Whereas indicators of obviousness would be that you have these predictable results that were obvious to a person who's in that field. You're applying a known improvement to achieve a predictable result, and you're using a known technique to improve a machine or development. And or your invention is created from a prior art and you just substitute one singular element of it. Again, and that could be done using a known technique to improve a machine or device. Now, something that I thought was interesting in learning at the ILC for this is one of the first things we actually do when we get a new invention is we just look to see whether it's on Amazon, because we have these meetings with our clients and we're like, wow, that's so interesting. Like, I can't believe nobody's thought of that before. And then the next thing you know, you go on Amazon and it's already out there. And if it's already out there, then it's going to not meet this. It's going to either be obvious or it would be within the prior art. So you would not be able to get a patent on that. So once you feel like you've met all the requirements of a patent, you're going to write your patent application. And in your patent application, it's required this disclosure requirement. And the disclosure requirement is basically so you're describing everything that you know about your device and what it's going to do in a full, clear, concise, and exact terms, so that some person who is in that field of average knowledge in that field would be able to take your invention and make it themselves, and it's in the best mode that you know to do that invention. And so basically the whole purpose of this is because the United States is giving you a monopoly over that specific invention, because you're giving back to the field of science your knowledge that only you have. And so they give you that monopoly for that 20 years since you file. And then after that 20 years is up, anyone should be able to use your technology in order to better the field. So that's the hope with this disclosure, is that you've disclosed it in such a way that anyone else would be able to replicate it that has the same knowledge in that field as you. So the types of patents that exist, the most common would be this utility patent. And a utility patents are granted to new machines, chemicals, and processes. So kind of what we've been discussing, just generally, a utility patent is what people are trying to get. The second type of patent is this design patent, and these are granted to protect the unique appearance or design of manufactured objects, such as the surface ornamentation or overall design of the object. And then the last is this plant patent, which are normally only given to botanists, and that's when they're able to make new plants out of asexual reproduction between two plant species. In undergrad, I actually worked with a professor who was trying to get a plant patent. He did not get one when I was working with him, but again, those are very rarely seen unless you're working in a botany lab or with a botanist one-on-one. More likely than not, you'll be seeing people apply for these utility or design patents. So then the type of patent applications that exist, the first that we have on the slide here is this provisional application. And the provisional application is just this placeholder. So it is, you're filing it and you're just generally disclosing what you want. And that's, so, you know, the times where we most see this provisional application is, you know, you've held a meeting or you've sat at a conference and you've discussed and you've disclosed your product, or you've written a paper, and that 12 months is about to expire on the exception of the prior art example. So because of that, you want to get that provisional application in so that you're not barred from getting your patent. But then after you file your provisional, you still have to file the non-provisional application, and the non-provisional application is where all of those requirements of disclosure and all of that come in. So while the provisional application doesn't have those requirements, in order for you to actually get the patent, you'll have to file a non-provisional application that will relay all of that information. And then there's the PCT application, which is the Patent Cooperation Treaty. And this is a provisional application for international patent applications. So it acts as the provisional application, but for the globe. So you would file for a PCT, and that would give you a provisional application globally. And then you could go out and explicitly file your non-provisional applications in other countries, whether that be China, Japan, Germany, the United Kingdom, wherever you'd want to look outside of the United States, you'd be using a PCT application before you would do that. And the last example is a continuing application. And this allows for the continuous of a previously filed patent application. So the one place where I've really seen these be in effect is in medical devices. And let's say, you get a patent approval from the USPTO's office, but then when you try to bring your device to the market, the FDA, just because of the regulations that they have to do to observe before you put that into the market, that's delayed the process in getting to the market, let's say by a year. You can file for this continuing application, and the USPTOs will likely approve that and allow for this continuing application. And then I have a video. So I'm going to pause this video halfway through, and I'd like you to just add in your comments and just let me know what you think was patentable in this video. Okay, so does anyone have any ideas of what was patentable there?
I don't think they can just speak up, and there's no chat. They have to ask it as a question.
Oh, okay.
That's correct. Or they could raise their hands and I can unmute them.
Oh, okay.
Okay.
I'm not seeing any hands raised, so.
Was it the dance?
It's not the dance. So dances are not patentable, but they might be copyrightable. It's something that he's using in his dance. And that's fine if nobody knows. The rest of the video will kind of disclose it, but it's not the dance. So let's see what it was. So Michael Jackson had patented his shoes, and his shoes had this little rivet in it that allowed his shoe to get caught on a nail that would allow him to do that leaning without falling over, and they called it a method and means for creating an anti-gravity illusion. So it actually was the shoe rivet that was at the bottom of his shoe that was the patentable invention here. And so just to kind of give you an override of what you would be putting in your patent application and what those may look like, we have the Michael Jackson patent here for you. So the first thing that you would have, you'd have the name of your invention, your inventors, and then this assignee. And the assignee would be who the inventor is giving, who's giving the rights to. So typically, if you are a professor at an undergraduate university doing research for them, then you would assign the university. Here, Michael Jackson is listed as the inventor, but they're assigning Triumph International Inc., which I believe is the people who are actually making the shoe. So that's who they assigned the rights to this invention to. So then the next thing that you see on this patent application is this abstract. So the abstract is kind of comparable to what you would put in a non-provisional patent application. So the provisional patent application, you're just generally saying. So the abstract is just generally saying, you know, what you want from this patent application. And then you go into this method and means section, which is giving the background of the invention. So with the background, you're providing, you know, the field of the invention, and then you're providing the description of prior art. So if anything out there exists or relates to your invention, then you'll be providing that in there. And then you get into the most pertinent part of a patent application and a patent, what your patent will actually be, which will be for these specific claims. And again, that's where you're putting in that clear and concise language of, you know, saying exactly what your patent is able to do and the means in which it's able to do that in the most clear and concise way so that anyone else can replicate it. And then if you have figures or descriptions that would make it easier for the patent person to observe, then you would include those also in your patent application. So here, Michael Jackson, you can see this on the left side, provided a drawing of what the shoe rivet would actually look like. And then the numbers that are coming off of it are the claims that relate to that specific part of the shoe, and where the claim comes from in relation to what the actual invention looks like. So that's kind of what you would have to include within your patent application and what you would have to show to the patent examiner at the time of your filing. So then the next question will be, well, if there is a patent that's out there, would you still have freedom to operate even if you can't patent your technology? So there are ways that you can still put an invention in the market even though somebody may have patented it. So if that old patent is expired, and a patent can be expired in one of two ways. So one, it's the end of the patent term. So, you know, it's 20 years after they filed and they no longer have the patent exclusive rights to it. So anybody else can enter the market with that patented invention. And the second way is there's these non-payment of maintenance fees. So if the individual who got the patent on that technology isn't paying their fees, then you would be able to put your invention into the market because they haven't maintained their exclusive rights to it. Then other ways are if there are or if there's already been disclosures in prior art and there has been no patent put on it, and those prior art statements are over 1 year, then you would be able to put your products into the market without fear of infringement because they didn't get a patent on that before the prior art term was over. And then there's not for sale. So this would be, you know, you look on Amazon and you see that similar people are selling it. So it's not, you're not the first person who's trying to sell this, and there are multiple other vendors who are selling it. It's not a monopoly of that specific invention yet. And the last way would be obtaining this license. So this is where you would go to the person who has the patent and you would say, I'd like to license this from you. You pay them a certain number of fee that they designate, and then you're able to use that patented technology and enter that into the field with your technology, even though they're supposed to have the exclusive right to it. So that's with patents, and now we're going to move into trade secrets. So
Sierra, before we do that, we do have one question here about patents.
Okay.
Okay, it says, can one get a process patent if I am not inventing, but rather using existing technologies to create a process that I do not believe already exists?
So if you're creating an entirely new process, then that would be a process patent, I believe. But Brian might have more that he could touch on that.
Yeah, I mean, potentially, you know, you can get what's called an improvement patent, which is an improvement on an existing process, you know, but it still needs to pass the same criteria. I mean, in this instance, you're more or less evaluating obviousness. So would a person of ordinary skill in the art, based on their review of the art, come up with a process that you are championing as your invention? So the answer is potentially yes.
Thank you.
Yeah, no problem. So with the next section, now we're going to be going into trade secrets. And so a trade secret is a formula, pattern, physical device, idea, process, or compilation of information which is not generally known or reasonably ascertainable by a business, by which a business can obtain an economic advantage over competitors or customers. So ownership of a trade secret is kind of a convolution of what it really is. Like a trade secret, you can't own it. You just have control over who knows the secret. So, and by keeping your circle smaller, you're ensuring that it is in fact a trade secret and you are able to get the most out of this economic advantage without your competitors finding out about it. So 3 essential elements for a court to be able to find that you actually have this trade secret is that it's a secret, you've taken reasonable steps to maintain that secret, and that there is commercial value in what you're keeping a secret. So ways that the courts will look to see if you have actually attempted to maintain this trade secret, they'll look to see whether there's restricted access to the information, whether you've used confidentiality labels when you have been providing information or how you're housing it. You limit the number of people who know the information. If you're telling someone the information, you're making sure they're signing confidentiality agreements or NDAs. You're encrypting the information. So if you have it, online, you're ensuring that it's in an encryption form so not anybody can get access to it. Again, it's not an ownership, it's just, you're maintaining control over that secret. And the most important thing to note here is that you're documenting all of the ways that you're attempting to maintain the secret, and you're doing this with its utmost protection because you want to maintain that financial control over whatever you're trying to maintain a secret. So what are trade secrets? There's the Coca-Cola Coke recipe, that's a trade secret. Who gets on the New York Times bestseller list and how they get on that best time sellers list, that's a secret. The Google algorithm, that's a secret. The KFC spices and the amount of the spices that go into their batter mix, that's a secret. And my personal favorite trade secret that I learned about as a child is the Krabby Patty secret formula recipe. That was kept as a trade secret. So these are all modern day examples of what a trade secret would look like. And as you can tell just from this short list of them, trade secrets are everywhere and they're nowhere because, we know of all of these things, but again, we have no way of knowing them. And all of these are examples of how you can maintain a trade secret and have an economic advantage in doing so in specific cases. So the next question would be for you, do you want to get a patent or do you want to have a trade secret over your invention? And just to cross compare the two. So for a patent, you're going to have 20 years of protection if it's a utility patent and 15 years if it's a design patent. And if you have a trade secret, it's potentially forever. It's just however long you can maintain that secret. And then if you have for legal remedies of the two. So with a patent, you're going to sue for patent infringement, and that could give you reasonable royalties, lost profits, willful infringement, attorney fees, and an injunction. And so an injunction is just making sure that whoever else is using your invention, that they're stopping using it. Whereas with a trade secret, you can sue for misappropriation of the secret and you can get damages, punitive damages, attorney's fees, and you can get an injunction. But again, to kind of keep in mind in the back of your head with a trade secret injunction, you can't really draw back a secret once it's already out. So, while you may be able to get that specific individual to stop using your thing, then everyone knows your secret and it's kind of lost its value. So that's the main drawback to a trade secret is that, your secret could be disclosed by this poor secret keeping. Somebody could reverse engineer your product and then just make it, or there could be independent creation that in no way they don't need your specific knowledge. They've just created it themselves. And then you would not have any legal remedy to maintain that for you. Whereas with a patent, the drawbacks would be, your patent could be found to be invalid. There's this high cost of litigation, and it's limited by the specific countries where you're actually filing your patent applications. And then for the cost of the two, with patents, you have this high cost to apply and maintain, with that being around $5,000 to $15,000 plus fees. Whereas with trade secrets, it's whatever that cost is to maintain your secret. So, whether that's Mr. Krabs having his safe and keeping it in a jar and making sure nobody can get to it, or whether that you're Coca-Cola and you're making sure people sign NDAs, you keep that entirely under wraps and you pay high paid attorneys to ensure, you keep that secret under wraps. So those are kind of the cross comparisons of the two, and whichever you think would be best for your project long term is where you could find it. Another thing to keep in mind when you're deciding between a patent and a trade secret, you know, the number one benefit of a patent is you're putting this out and you're fully disclosing it. So you're advancing science and you are able to give this secret out to society so that they could either, you know, better your project and then add to it and bring more to society to even further better science and technology. Whereas with a trade secret, you know, you're keeping that to yourself. So you're not disclosing that to the public. There's no way for people to replicate that or improve upon it or make it better unless they are able to do a reverse engineering or independent creation of their own for your invention. So whether you want the public at large to know that and do better science in that way could be an indication of whether you would like to get a patent or a trade secret as well. So that's patent and trade secrets. And with that, I will turn it over to Chris, who is going to talk with you guys about copyrights.
All right. Well, everybody. So copyright. What is a copyright? Well, copyright was first introduced in the U.S. Constitution, where in Article 1, Section 8, Clause 8 states, and I'll paraphrase this, that Congress shall have the power to promote the progress of science by securing for limited times to authors the exclusive right to their respective writings. The same clause that grants the power to issue patents is also the same clause that establishes copyright. Remember, the motivation of this clause was to provide an incentive for others to create. So in 1976, Congress passed the Copyright Act, which completely laid out the copyright framework we use today. We define copyright as protection in original works of authorship fixed in any tangible medium of expression. With this definition, there are 3 requirements your work must have in order to be awarded copyright protection. And those requirements are here on the slide. They are work of authorship, originality, and fixation. So let's look at the first requirement, work of authorship. So in the Copyright Act, there are 7 categories of works of authorship laid out by Congress. These works include literary works, such as books, magazines, newspapers, song lyrics. The next is computer software, then pictorial graphics and sculpture works, otherwise known as PGS works. There are architectural works, including building blueprints, then sound recordings and accompanying words, audiovisual works, such as movies and television shows. There are dramatic works and accompanying music like plays. And finally, there's pantomimes and choreographic works, such as dances. And an example of a copyrighted dance, one that I found out just before I logged on to this webinar, was that just last year, the choreographer for Beyonce received an approved copyright for his Single Ladies dance. I guess it was a long, hard-fought battle, but last year now you know that dance is copyrighted. So it's essential that your piece falls into one of these categories in order to have copyright protection. So the next requirement is originality. Works must be independently created and satisfy a minimal standard of creativity. That standard for originality is relatively low. Protected art does not have to be fine art because taste differs. Some things that may seem original that are not copyrightable include words, facts, ideas, randomly arranged components, and theories. Einstein can't copyright his theory of relativity. An important rule in copyright is that ideas are not protected, but the expression of the idea can be. And expression is often defined by our next slide, which is fixation, the third requirement. So when we say fixation, we mean that the piece must be fixed in a tangible medium of expression, whether that be the moment you write down words or you press record on your camera. Copyright protection vests at fixation, regardless of whether you've registered your copyright or not. However, you cannot sue for infringement until you registered your copyright with the Copyright Office in the Library of Congress. Thankfully, copyright registration can be applied retroactively if infringement's already occurred. So to register your copyright, you have to make a claim of copyright. It's possible that you may be denied for your copyright claim. After all, copyright protection is not guaranteed. The duration of your copyright is generally the life of the author plus 70 years after the death. Works made for hire, that is when you author a copyright while under employment, can last 95 years to 120 years from the creation, whichever expires first. On the next slide, we have ownership in copyright. ownership of a copyright will vest in the original author of the copyrighted work, unless a copyright is a work made for hire, where the ownership has been transferred. In that case, the employer is considered the author for work made for hire. If you're an independent contractor, you would need some sort of NDA, non-disclosure agreement in place, or contract in place in order for it to be considered a work made for hire. The copyright owner has the exclusive right to reproduce, to prepare derivative works, and distribute copies of the work. The distribution right only extends to the first sale of a copy. For example, if I buy a book that's protected by copyright, then I am free to resell that book without fear of infringing on the original copyright. We call this the first sale doctrine. So speaking of infringement, on the next slide, we have infringement. So in order to prove infringement in a copyright, the plaintiff must prove, 1, that actual copying occurred, and 2, the work was improperly appropriated. So first, for actual copying, it can be proved through either direct or circumstantial evidence. As you can imagine, direct evidence is not easy to come by. Direct evidence can include admissions of infringement or witness testimony that actual copying occurred. We also rely on circumstantial evidence that can include evidence of access, strong similarities between the works, whether it was copied from another source, evidence of independent creation. We consider the length of the work or the complexity of the work. For the second prong, improper appropriation, it can be inferred if both works are substantially similar. Fair use is a common defense against infringement. Oftentimes you'll see it written as a Section 107 defense. Fair use defends copyright infringement for criticism, comment, news, reporting, education, and research. Those categories are taken directly from the US Copyright Act. In order to prove fair use, we look to the purpose and character of the use, meaning whether or not the infringing work replaces the original in the market. We look to whether the work was published or unpublished, whether it's fact or fiction. We look to the amount used in comparison to the whole, and the effect of the overall use has on the market. Ultimately, the use of copyrighted work must be transformative, meaning the work was more than a mere reproduction. In an example of fair use defense is parody. On the next slide, we have a famous example. Roy Orbison released this song, Pretty Woman, in 1964, and he died in 1988. His copyright for the song ran 70 years past his death, so he holds the rights of his song Pretty Woman until 2058. Before his death, 2 Live Crew asked Roy Orbison if they could sample Pretty Woman. Roy initially refused, and when he died, 2 Live Crew released the song anyways. The song isn't an exact copy, the sound is remixed, but the lyrics are changed. The Supreme Court, in their opinion, examined each fair use factor we described above and held that this use was protected under fair use and that there is enough evidence to support that this song could actually be a parody. This appropriation of Roy Orbison's Pretty Woman passed the fair use test. And we can go ahead and give it a listen and judge for ourselves whether or not we think that this is fair use.
Pretty woman, walking down the street, pretty woman, the kind I like to meet, pretty woman.
And now 2 Live Crew.
Pretty woman, walking down the street, pretty woman, girl, you look so sweet, pretty woman, you bring me down to the knees, pretty woman, you make them wanna beg, please. Oh.
There we go. So fair use. Let's move on to the next slide. The final piece of intellectual property we'll be discussing is going to be trademarks. So trademark is a word, phrase, symbol, or design or combination thereof that identifies and distinguishes the source of goods. The framework for trademark law is the Lanham Act, which lays out the requirements for trademark protection. That is, trademark must have acceptable subject matter, must be distinct, and it must be used in commerce. In order to obtain federal protection, the trademark must be used in interstate commerce, that is, between states. We've all seen the small TM at the end of a logo used to designate a trademark. Well, the TM symbol is used on a trademark before you've registered it. Once a trademark is registered, then you may use an encircled R at the end of your logo, and trademark protection will last as long as you are using the mark. Below we have some examples of some famous trademarks. We have Twitter, Lego, Pandora, Nintendo, and we'll get into later why it's important, why you may want to consider registering your trademark. So on the next slide here, we have what we call the Spectrum of Distinctiveness. So each mark is given a specific, each mark is given a descriptive term that determines how strong the mark actually is. We rank the strength of each trademark based on the type. And starting at the top, we have generic, seen here in red. It's the weakest type of trademark that won't allow you any protection. Any generic trademark is a trademark that is the common name of the product or service. They're said to be so descriptive that they're incapable of ever functioning as a mark. And these marks include aspirin, flip phone, laundromat, videotape, words so common that they wouldn't be ascribed any sort of distinctiveness and therefore no trademark protection. The next type of mark is descriptive. A descriptive mark merely describes an ingredient, a quality, a characteristic, a feature, a purpose, the use of the product. And since it's not inherently distinctive, a word may acquire distinctiveness over time through the use and promotion of the mark. We call this the secondary meaning, and it's proven by a mark owner showing that the primary significance of the term is the producer, not the product. Some examples of descriptive trademarks include British Airways, or Louisville Slugger, or Omaha Steaks. Next suggestive mark, next is a suggestive mark. A suggestive mark merely suggests a quality or characteristic of the product or service, but requires some extra thought to connect the mark with the product. Some examples may include Netflix, which is a combination of internet and flicks, as flick, a synonym for movie, or Coppertone, or Under Armour, or as we have here on the slide, Microsoft, which is suggestive of software for microcomputers. As you can see, descriptive of the product, but takes a bit of a mental step for you to figure out what it is actually that they're trying to say. Under that, we have arbitrary marks. Arbitrary marks are marks that have common meaning, no relation to the product or service to which it is used. These kind of marks are inherently distinctive, and they include Apple, Dove, Shell, all marks that have nothing to do with the products that they sell. And last, we have fanciful marks. These are marks that are made up and have no meaning, and they are by default distinctive. And these marks include Kodak, Exxon, and Polaroid. And remember, this is the spectrum of distinctiveness, so the final three in green there. If your mark qualifies as one of those three in green, it's likely that they will be found distinctive. So let's move on to trade dress. Trade dress is a subset of trademark that protects the total image and overall appearance of an object. Notably, trade dress protects purely aesthetic features like the shape, color, and graphics, and not functionality. Functional means it is essential to the use of the article or it affects the cost or quality of the article. As an example, we have the shape of a Coke bottle or the shape of a Converse shoe. We have the shape of a Jack Daniels bottle there on the right and the red bottom of a sole of a Louis Vuitton shoe. Below, we have an iPhone and a Samsung Galaxy. Apple initially sued Samsung for violation of their trade dress, protecting the shape of their iPhone, particularly the rounded edges. And ultimately, Apple lost because the court found that their rounded edges were actually functional. The rounded edge gives a utilitarian advantage of easy thumbing and ability to fit better in your hand. So therefore, there couldn't be any trade dress protection. So Apple lost. Let's move on to the next slide, is trademark infringement, where trademark infringement works by establishing priority. Namely, the first to use the mark owns the mark. However, a second user is not infringing if the second user was using the trademark in a remote market and the second user used the mark in good faith. Underneath, we have an example there of Pandora. We all know Pandora as the musical radio station. But we also know Pandora as a jewelry store, a popular jewelry chain in most malls. And the reason why both of these trademarks can exist simultaneously is because they address different markets. Therefore, there's no infringement. When someone registers their trademark, however, then that registration is said to be constructive notice of ownership and negates good faith use of that mark. So if you're worried about infringing on a trademark, you can search public database online for free at the USPTO website. And if a trademark you want is not registered, then you'll get priority for the mark in your area. Requirements for trademark infringement are that the mark is registered, the mark was used in commerce, and commerce does not require that the mark was used across state lines. There must be some connection between the sale and the use as a trademark. After all, the goal of trademark law, what we're trying to accomplish is to prevent consumer confusion. We're concerned with confusion as to the source, affiliation, and impact of different marks. We want consumers to know and be confident in the products that they're buying. So like trademark law, like copyright law, trademark also has a fair use defense, which is on the next slide. There are two types of fair use defenses for trademarks. We have descriptive fair use and nominative fair use. Descriptive fair use is when the defendant's use is not used as trademark, but used to describe goods or service. For example, we have on the right here Bell v. Harley, where Harley-Davidson used the words ride hard on an advertisement. That allegedly infringed on Bell's ride hard trademark, which we see up against the Harley-Davidson ad. The court ultimately held that Harley's use of, ride hard was descriptive. It was descriptive fair use. It was used merely as a description of Harley-Davidson's ad and didn't infringe at all on the trademark of Bell. Underneath that, we have nominative fair use, which is when the defendant uses the plaintiff's mark to refer back to the plaintiff. An example of this is New Kids on the Block versus News America Publishing. News America Publishing published polls in newspapers asking readers to call in and answer various questions about the members of New Kids on the Block. And they did that while saying the name New Kids on the Block. So the group, New Kids on the Block, thought that this was infringing on the trademark of their own name for publishing their name. The court held that this nominative fair use applied here, and that the publishing company's journalistic effort could use the trademark name New Kids on the Block in their effort to pull readers about how they felt, that this description was merely referring back to the plaintiff's referring back to the plaintiff's trademark and not infringing on the trademark itself. So that's what we have for trademarks. And that ends our discussion of different intellectual properties available that you can consider for your company.
Thanks so much, Chris. So if anyone has any questions, please enter them now. We do have one question here in regards to trademarks. For a business that's considering using the TM logo, how do they determine whether their use would be valid or not? In other words, is it potentially something that is not trademarkable that they may be considering putting the TM logo next to?
Well, I mean, I guess the question is it some kind of obscene term or something like that? Then, you know, that may not be subject matter eligible for trademark registration. If it's a traditional business name, you know, we encourage clients to put trademark next to the name, because the whole issue with common law trademark versus federal trademark law, which is the registration part, is, and as Chris alluded to, you get local or geographic protection for your common law trademark. When you file on the federal register, you can get countrywide, nationwide coverage for that mark. So if you're using it in commerce in a locale, you know, we recommend that you put the TM logo after it, just so that there's no confusion later on to say, you know, when you go to file either for a federal registration, or you get into a dispute with someone who then tries to file for a federal registration, you know, with that same name, trade name, you have evidence of, hey, I've been using this as a trademark for, you know, 15 years in central New York. So, you know, the more you can document, with most things in business and operating a business, the better off you are.
Is there any risk to potentially using the TM, say for a name that you didn't realize somebody else already has trademarked? And so now you're claiming a trademark on something that in fact already is trademarked?
I mean, you can do that a couple different ways to kind of protect yourself. You know, do a Google search first and foremost, see what other names are out there. The U.S. Patent and Trademark Office, the website, you go under the trademark folder. You know, there's a database in there. You can search the names that are already registered. And so, you know, I think where this question's going is they're worried about infringing upon an existing trademark. So one way to, you know, cut that off or limit that exposure, potential exposure, is to conduct your own search at the trademark office to see if those names are already taken or, you know, if they're still an active trademark. There's other sources. You know, when we conduct a search for a client, we'll not only look at the Patent and Trademark Office, but, you know, you got to search the government. So like New York State, the Department of State, the Division of Corporations, you can do a search in there, see what trade names have already been taken for names of businesses. So as long as you're doing your due diligence, you know, you would have some type of defense. You may have a fair use defense, et cetera, but you know, there's obviously a lot of factors that go into that, and I don't want to go down this path too far, but yeah, in order to protect yourself, conduct your own searches in publicly available databases before you start investing a ton of money in a name. And you know, you get a year and a half into this thing, and you pumped a lot of money into this, and then you get a cease and desist letter from, you know, the trademark owner that has that name, when, you know, a simple search would have uncovered that a year and a half ago.
Thank you.
I can think of a real quick example. There was a coffee shop, and they named their coffee shop Federal Espresso, but Federal Express, and they referred to it as FedEx. So FedEx obviously had a problem with that, and they had a registered trademark. And so they got the cease and desist letter that you're talking about. And so they ended up changing their name to Freedom of Espresso, so that they would be free to operate their coffee shop. Not that there would be any confusion between shipping services and a cup of espresso, but that's sort of the way it went down. And they could have saved themselves a lot of grief had they anticipated that. But some of it is, you know, bordering on who has the deeper pockets. So.
Yeah, because another similar one, if you guys are from the Syracuse area at all or know around here, is with the Q's juice. There's a company, Lachlan Distilling in Phoenix, New York, that did the Q's juice, and then Syracuse sent them a cease and desist to not use Q's. So now they changed it, and it's excuse, like EXQs. So it's like orange excuse instead of the Q's juice. But
thank you. We do have a couple more questions here. Can you license a trademark to a third party?
I see Brian nodding his head.
Yes, you know, trademark, you know, you preferably, if you are taking the license, you want it to be registered. That way it gives you a lot more peace of mind that, you know, it's a legitimate mark and you're not going to get a cease and desist letter. But absolutely, trademark, you know, that's a right that you've got, that you can, you know, license it out if you want.
So like for an example is, obviously the McDonald's Corporation owns McDonald's. When you buy into or you purchase a franchise, when you franchise it, you're getting a license to use the McDonald's name at your specific location.
Thank you. How defensible is a registered trademark even though it is generally descriptive?
That's going to cost you a lot of money to prove that. You know, that it's highly fact intensive whether or not a mark is descriptive. You know, you actually get consumer studies. You know, it's an expensive proposition. Doesn't mean it can't be done. It's just going to cost some money in order to demonstrate that. You know, one of the ways you can challenge that is to kind of file like a competing application on that, and then the examiner may kind of reject that or give you an idea that they're going to reject it, and then you reach out to the other side and you try to work out an arrangement, you know, that you can use it in a certain class of goods, right? Because when you get a trademark, it doesn't necessarily mean you get it across every single class of goods. And so we have the Pandora example. One is in jewelry and the other one is in music. So, you know, you may still be able to, you know, get it in a very narrow class, which sometimes is good enough for the client. I mean, you just want to be able to use the name, so you can try to figure out and make arguments to the trademark office why you fit into this particular class and why that's so far afield from the existing mark that there would be no consumer confusion.
Thank you. So it looks like we just have one last question here, and that is, how do potential clients request assistance from the Innovation Law Center, and what is the cost?
Caitlin, you want to take that?
So if you guys are interested in our help, you can reach out to Carly or Molly, who I think Sierra can put up the last slide again, and that has their email addresses. As for costs, I'm not sure on that end. I know some of our projects we do use as educational and are pro bono, but then other ones are paid as well, or like you would pay for it.
Yeah,
Okay.
so
It depends on the speed of it too.
all right, so some of the projects are educational, which are no bono, we like to say, and then depending on the particular client, if they have the ability to pay, it's then what we consider low bono, but it's really done on a case-by-case basis.
Great, thank you.
Chime in. Yeah. The semester projects do take about 10 weeks for the client to get a result. The summer projects are much quicker, and those are the low bono that Brian was alluding to. So those are sponsored projects because we do pay the student researchers during the summer. And we do a lot more projects during the summer because they're obviously not taking classes at that point.
Yeah, and then Carly, our program coordinator's on. Oh, you're muted. But she's the one that kind of does a lot of our intake, I think.
Okay, thank you. It looks like that's it for the questions. Was there anything else that any of you would like to add before we wrap up today?
No, just thank you for the opportunity, and please feel free to reach out to us and you know, and let us know where we can help.
Well, thank you so much.
As do our students.
Thank you all so much for presenting on this topic for us. Again, my name is Zach Steffen. I'm a business advisor at the Mohawk Valley SBDC. If you're in the Mohawk Valley and you'd like to connect with us, you can do so on our website. It's mvcc.edu and click on business and then SBDC. We have an intake form on the website that you can fill out if you'd like to speak with an advisor. You can also call our office directly at 315-731-5884. I'd like to thank the Advanced Institute for Manufacturing for co-sponsoring today's presentation. The Advanced Institute for Manufacturing is also hosted by Mohawk Valley Community College, and they're located next door to us on Broad Street in Utica. We will be sending a follow-up email containing both the slides and a recording of this presentation later in the week. And after you exit the webinar, you will receive a brief survey. We'd appreciate it if you would take a moment to fill it out. Thanks again to all the presenters and to everyone who attended today, and have a great afternoon.
Thank you.